Welcome to Consumer Law, What Is It Good For? Challenges, where we look at specifically challenges or difficulties people face when trying to resolve disputes and challenge conventional thinking and the responses received to complaints and disputes. And in this episode, we're going to look at car finance complaints, and in particular, complaints about faulty and misdescribed vehicles bought by way of hire purchase or PCP agreement. Now, we will be doing a few videos around this subject. So in this particular case, we're going to look at a common problem involving complaints made after 6 months involving faulty or misdescribed cars, and specifically the interaction between the law and the Financial Conduct Authority rules, which govern, amongst other things, the way that finance companies and banks handle disputes from consumers. So by way of some background and to give a better example, I'm going to use a very recent case that came to us for advice. And in response to a complaint involving a BMW bought 18 months or so ago, Santander, the finance company, wrote this: "After a full review and investigation into the points you have raised, I'm unable to uphold your complaint on this occasion. The reason for this is that we have not received any evidence from you to indicate that the fault was present at the point of sale, nor within the first 6 months of inception. We are unable to hold the dealership liable due to the time elapsed, and the vehicle was not brand new at inception." So in summary, Santander raised 3 separate issues. One, in relation to the investigation. Santander claim they have carried out a full investigation into the complaint. 2, evidence. Santander say the customer was required to and has not supplied evidence demonstrating the fault that he complains of was present or developing on delivery. Number 3 is a limitation of liability. Santander state that there is no liability in contract between Santander and the dealer because 18 months have passed since delivery of the car. So at face value, in reading the response from Santander, it appears that there is an interaction between the FCA rules, requiring them to investigate the complaint, and the law, namely the law of evidence and contract law. So let's look at these issues one at a time. And the way that we often look at challenging responses we get from people and trying to hold their feet to the fire is really by a form of questions. So first, when I look at the Santander response in regards to the investigation, I say, how do you manage to carry out a full investigation, that's to say a systematic examination of the complaint, if this investigation is predicated upon the customer supplying to you specific evidence? The FCA rules state that the finance company must investigate the complaint competently, diligently, and impartially, obtaining additional information as necessary. Therefore, under the rules, the FCA rules, it seems that if there are informational gaps in the complaint, then Santander and finance companies in general must investigate those gaps and find the information that fills those gaps. And if they haven't done that, then by definition, the finance company has not complied with its regulatory obligations and cannot have carried out an investigation properly. How could they? So there's a potential additional regulatory problem that face people like Santander, in that one of their obligations or their key principles is to not cause consumers harm. And in failing to carry out that investigation, in principle, causes the customer harm because they've not had the complaint properly investigated, and that would potentially give rise to an increase in compensation if the matter were escalated to the Financial Ombudsman Service. So we've clearly got a problem in what an investigation entails and what Santander or finance companies are supposed to do. If we then moved on to the evidence factor, now in one respect, it cannot be right that a customer simply informs Santander or a finance company that the vehicle is faulty and leave them to fill in all the gaps. That would be like reporting a missing person to the police without telling the police the identity of the person, which can't be right. So how is it that the Financial Conduct Authority rules interact with the law? At this stage, there seems to be two separate camps. On the one hand, we've got to carry out an investigation, but on the other hand, you must prove that the fault that you complain about was present at the point of sale. The two things are in conflict with each other. But the answer is really quite simple. And we're just looking really at common law to help us with this. So simply, the first issue is that the customer must provide evidence which supports the car currently being faulty, because that's the complaint. The car is currently faulty, and that evidence should set out what the nature of the fault is and what's caused that fault. So by way of the example with our Santander case, that the customer provided evidence by way of a BMW diagnostic test or results, and also the repair estimate that in this particular case said it had to have an engine rebuild costing about £10,000. Additionally, the customer provided BMW diagnostic reports and repair invoices for the repairs that have been carried out historically over the past 18 months or so. Each of those repairs were in relation to similar symptoms, which in this particular case was all about the engine misfiring. Now, once the finance company received that, they've got the skeleton of this complaint that says within a certain period after delivery, I think it was about 6 months, for example, the vehicle developed a misfire. Those symptoms were treated by BMW. A few months later, the symptoms were repeated. They carried out some more repairs, and so on and so forth throughout that 18-month period. I think about half a dozen times it had been back to BMW, eventually culminating in the need for the vehicle engine to be replaced. So it's at that point, with that information, that the finance company, Santander, should pick up the ball and carry out an investigation in accordance with the Financial Conduct Authority rules. The question thereafter, once the investigation has been carried out by the finance company, is what they need to satisfy themselves of in order to determine liability. So whether that should be, they need to be satisfied that the BMW was defective from the outset, or whether the defect occurred within 6 months. If it did occur within 6 months, can the customer avail themselves of the remedies under the Consumer Rights Act? Or is it satisfactory enough just to determine that in a 48-month finance agreement, you expect the car to last 48 months and it hasn't? So is there just a simple case of lack of durability? Finally, is the limitation of liability that's brought in by Santander. And they are putting forward the idea that the dealer cannot be held liable to Santander because it's been 18 months of since its delivery, and somehow that Santander are barred or is stopped from bringing a claim against the dealer. So the first question we have to ask ourselves is that Santander are referring to a contract between them and the dealer, not between them and the customer. So we've got to ask ourselves, how is it the contract between Santander and the dealer has any bearing at all on the contract between Santander and the customer? But it doesn't. It's a complete irrelevance from that point of view. Secondly, even if there were some contractual relationship between the customer and the dealer, which there isn't, given that claims in contract are not barred under the Limitation Act 1980 until 6 years, how can the claim that Santander may have against the dealer be barred after 18 months? Well, it can't. So the reasoning that Santander have provided is wrong. It makes no sense at all. So in summary, when we look at this particular issue, and it's not uncommon with Santander, it seems to me that the first thing that they do is look at the date of the complaint compared to the date of purchase. Once they've realised or found out that the complaint is raised after 6 months from delivery, in this case it's about 18 months, my view is that automatically prejudices the next stage. They're automatically thinking, no, we don't have to carry out any investigation because the primary scenario is that the customer must first provide all the evidence that supports their claim from the outset. But that's wrong. That's not right. And it seems to me that finance companies in general are viewing the law and the FCA regulations as an either or choice, or even some sort of pick and mix situation where they can pick and choose which bits to rely upon in order to satisfy their financial conduct authority regulations. That can't be true. The reality is there's a very simple and practical interaction between the law and the FCA obligations. And you just start with that proposition that whatever information you are given, you must, it's not optional, it's compulsory. You must carry out that investigation into that complaint. And you must obtain further information as necessary. And that investigation must be competent, diligent, and impartial. So it's not going to be enough for a finance company just to refer the complaint back to the supplying dealer for the supplying dealer to investigate it, because clearly that would not be impartial. So the truth of the matter is, if you're in a position where you've made a complaint to a finance company about a car that you bought on hire purchase or PCP, and that complaint gets raised after 6 months or so, and you get a response that says, no, we can't take this any further, we're not upholding your complaint because you've not provided that information, then you must challenge them. That is not right. The only way that the finance company can fulfill their overriding principles of fairness, good faith, and impartiality is to apply the FCA rules and the law together. I hope this video has been useful. If you have any questions or you have problems in this regard, please give us a call here at Stormcatcher Law.